Well, welcome to the annual Kastenmeier lecture. I'm delighted to see you all today, and we have a wonderful lecturer for us this afternoon, who I'll introduce in a moment. This is one of our marquee events of the year, and appropriately so, because it presents us with the opportunity to remember someone who was and is very dear to our community, the late Representative Robert W. Kastenmeier, a graduate of this great law school, who served in Congress for 32 years until 1991. And during his time in office in Congress, championed many important issues, but among them were intellectual property, including copyright and technology law. And so, we kind of rotate the subjects for this. And every few years, we try to do one that addresses some intellectual property subjects, as we'll be doing today. Today is actually the 30th Kastenmeier lecture, as hard as it may be for those around here who remember the first one. I went back and read the law review article that became of that first lecture earlier today, which was delivered by then Chief Justice William Rehnquist. This lecture is only possible due to the generous donations to and support from the Robert Kastenmeier Fund. We really appreciate those who have made gifts to this fund in the past. And if you're interested in doing so in the future, Liz Feist from our team at the Wisconsin Foundation and Alumni Association would be more than happy to speak with you. I do want to commemorate, with apologies to anyone I missed, just a few of the people who we have in the room with us today. We have Judge Barbara Crabb. Judge Crabb, we so appreciate your being here for this lecture every year. Thank you so much for taking time out of your schedule to join us. The same for Judge Kim Peterson. Where are you, Judge? There you are. You're right over there. Thank you for joining us as well. And right next to him, Justice Ann Walsh Bradley, who assures me she's not counting down the day. And probably so, because the longer that time goes, from my perspective. And then Judge Remington is also in the room. There you are, right. Thanks for being here. Wonderful to have you. And of course, we are always honored to have with us the Kastenmeier family, Edward Kastenmeier, as well as Dorothy Kastenmeier, the widow of Representative Kastenmeier. Thank you so much for making the trip to be with us today. We love remembering Representative Kastenmeier and are deeply honored by your taking the time to be with us. Our keynote speaker and the deliverer of the 2024 to 2025 Kastenmeier lecture is Pam Samuelson, the Richard M. Sherman Distinguished Professor of Law and Information at the University of California, Berkeley Law School. She's a pioneer in digital copyright law, intellectual property, cyber law, and information policy. Professor Samuelson directs the internationally renowned Berkeley Center for Law and Technology. She serves on the board of several groups, including the Electronic Privacy Information Center, the Center for Democracy and Technology. She's also the co-founder and chair of the Authors Alliance, a nonprofit organization that promotes the public interest in access to knowledge. She has an extremely long list of publications. I'm not going to try to get them here, but these, one of the most recent ones, a subject of great contemporary interest, generative AI meets copyright in science, published last year. She's going to be speaking today on justifications for fair uses. Please join me in welcoming our 2024 to 2025 Kastenmeier lecturer, Professor Pam Samuelson.
Thanks very much for being here. Sure. Robert Kastenmeier is one of my heroes. I actually knew him, and he was so that was all the more reason why, when I was given the invitation to do this lecture, I said, I gotta do this. So I'm glad to be here. And I want to give you just an overview of what I'm going to do. I'm going to talk a little bit about Robert Kastenmeier and the important contributions, at least some of the important contributions that he made to our country. And I'll talk a little bit about copyright and fair use doctrine, because that was one of the important things that happened in the codification of copyright law for the future in 1976, and talk about controversies involving new technologies, because it turned out that fair use turned out to be really important in some of the new technology cases. I'll talk a little bit about some of the developments in the last decade or so, and I'll talk about why I think we need to be more cognizant of the types of justifications for fair uses that there ought to be. And so I'll give you my little taxonomy of fair use justifications, because a recent Supreme Court decision has been interpreted by some as narrowing very considerably the justifications that can be offered when somebody is raising a fair use claim or defense. Okay, so two big contributions that he made, of which I'm aware, are shepherding through the Copyright Act of 1976. Now, this may not seem like a big deal to you, but it was a very, very, very big deal. Okay, it took more than 2 decades to go from the time that they decided that they wanted to move in that direction to the actual passage of the act. There were many new technology issues in particular that were very controversial, and so controversial that he had a bunch of hearings on it. And one of the things that made him unusual is he wanted to hear from people. He didn't want to just say, oh, I'm going to stack this deck in the way that I want. He actually wanted to hear from people. He wanted to know what different points of view were. He wanted to find some common ground insofar as that was possible. And I think that's a really commendable thing. So part of what the goal of the 76 Act was to recognize that we were in a time of rapid change technologically, and we needed a law that was not brittle, that would actually be adaptable over time to new technologies. Another major contribution was the shepherding the Byrd Convention Implementation Act
through Congress. This also was not the easiest thing in the world to do because the United States had not joined the Berne Convention, which dates back to the early 19th or to the late 19th century. We didn't join it because we didn't want to, right? We didn't like their rules. And so we had to make quite a few changes to the act in order to be able to join the Berne Convention, because the Berne Convention basically says, you want to be a member of our convention, you have to agree to copyright law that includes these following things, and they're minimum. You can't get in our club unless you do what we want you to do. So now that's actually the international treaty that everybody else who was big in the copyright space, they were all members of that club, and the United States couldn't sit at the table and couldn't really negotiate without having joined the convention, and it ended up being a huge boon to domestic copyright industries, as well as to facilitate global trade. Now, in the course of researching for this talk, I realized that he also did something that we all should be grateful for, which is, again, shepherding the Electronic Communications Privacy Act. So if you think that you have any privacy in cyberspace, guess who is partly responsible for that? Yes. Okay, he's also super interested in new technology. And so while I have written articles basically saying, I don't think copyright for computer programs is a particularly good idea, nevertheless, he was the one who shepherded this through. And the first time I ever tested for Congress was actually about the scope of copyright protection in computer programs, because the courts were really pretty messed up about it at the time. And I had been studying it. Now, I'm not myself a technologist, but it turns out that if you work hard as a lawyer, you can learn almost anything. And so there's Henry Adams, I think it was, who said, he knows enough who knows how to learn. So I've been learning my whole career. And another thing that was pending, actually, in the 1980s was a question about whether copyright or some new kind of protection should be available to the layout of the circuitry of semiconductor chips. And some people in the Senate wanted to use copyright. And Kastenmeier said, I don't think this is a good idea. And so he and others worked to develop a Semiconductor Chip Design Protection Act. And Michael Remington and Kastenmeier actually wrote a Minnesota Law Review article saying that, hey, if you want Congress to be receptive to the idea of either a new form of protection or a broader scope of protection for some intellectual creation, here's what you have to show in order to deserve it, okay? So it's really kind of putting down a marker about what kinds of things ought to be part of a conversation. He also gave a lecture, which was published in a law review under the title, Copyright in an Era of Technological Change, which meant he kind of reviewed a bunch of the new technology issues that he had seen over the course of his career. And in that essay, he talked about regretting not having held hearings about software copyright because the courts got kind of all messed up about it, and they didn't have any legislative history to help guide them on whether this was a good idea or not, or how to interpret copyright in relation to programs. Okay, so among the things that happened in the 1976 Copyright Act was the codification of what had been a judge-made doctrine of fair use. So fair use is a limitation on the scope of rights that authors are granted by the Copyright Acts. And one of the things that the 76 Act did is, so here are your 5 exclusive rights, copyright owners, but they're all subject to fair use, among other limitations and exceptions. So the codification was really important because the case law is kind of like, well, I know it when I see it. And so one of the things that happened with the codification was the articulation of here are the 4 things that you should consider when making a fair use determination. So the purpose and character of the challenged use, the nature of the copyrighted work, the substantiality of the taking, and the effect of the challenged use on the market or the value of the copyrighted work. So all of a sudden you have a framework, right? You know what you're supposed to be looking for. And so the case law basically started evolving to understand how the fair use balance could be. Now, the legislature does a really nice job of sort of explaining that fair use balancing. It's a rule of reason for balancing what the copyright owner interests are and what the other interests are, public interests, the interests of follow-on competitors and the stuff. And this is particularly needed in an era of rapid technological change because Congress can't think through all the stuff that's going to happen in the future. And having a kind of a balanced structure to work with was something that was really important. And it recognized that there's an endless variety of circumstances to which fair use should and could apply. And so it's not just book reviews, and it's not just this, it's not just that. It's like an endless variety of circumstances. And boy, has that turned out to be true. It also articulated criticism, comment, news reporting, teaching, scholarship, and research as favored uses, right? These are not definitely, if you do have one of those, that you win, but it is a case that these are the uses that promote the progress of science and the useful arts, which is the constitutional purpose of copyright in the first place. Now, it turns out that the author and publisher groups and the library and educator groups had been at war on this particular issue. And so by putting these things into the statute, at least gave the court some guidance about what to do. Now, you will find it probably odd that photocopying and home taping used to be the big deal. And honestly, another one of these wars. So back in the 70s and 60s, biggest controversies were the legality of library photocopying of articles for patrons and home taping of recorded music. And the Publishers Association and the recording industry were like, you got to pay for every copy, period. And you got to keep track of every copy. That got tested for the first time on the photocopying side in the Williams and Wilkins versus United States case. So NIH basically said, look, you scientists who come to my library, and you have this one article that's really and you want a photocopy of it? Well, I'm not going to make endless photocopies for you, okay? But if it's a one copy of one article, I'm good. And then Williams and Wilkins basically challenged that. So even though his articles were only, his articles that were alleged to be infringed, only 8 of them, right? 8 articles. And they had 40 journals. Excuse me, there's no market harm from that, okay? But nevertheless, the appellate court, an appellate panel, split 4-3 on this issue. It went up to the Supreme Court, and the Supreme Court split 4-4. So left that controversy over photocopying even of single articles was potentially in home taping, similar kind of thing. While Kastenmeier was the chair of the House IP subcommittee, some legislators, again at the urging of the recording industry, proposed to create a tax on tapes and tape machines to compensate sound recording copyright owners for that home taping that was happening. The Office of Technology Assessment at Kastenmeier's request, did a study about home taping and discovered that 4 of 10 Americans were home taping music all the time, and that there were billions of copies of this stuff that had been made. Sound recording industry said, oh, billions and billions of dollars of loss. And the OTA basically said, I don't think so. During the time that Kastenmeier was the head of this committee, he was against this legislation, but it passed after he left. And it turned out to be a disaster. Okay, so it was like a complete failure. So he was right and other people were wrong. Do you like that? Only $54 basically at the last payout. It's like completely didn't work. Okay. Sony Betamax case, again, was where the copying controversy came mostly to a head. So for those of you who are not familiar with this case, Universal, City Studios, and Disney basically said, Sony, you are selling these Betamax machines to allow people to make copies of programs off broadcast television. And that's unauthorized and illegal, period. And so you're a contributory infringer to user copying. The Ninth Circuit actually agreed, notwithstanding the fact that, honestly, the harm to the market is like really just speculative. So the Supreme Court, by a 5-4 margin, notice how close these cases, personal copies and home taping and stuff, how close they were. But the court basically said, look, it's fair use to make time shift copies of television programs. And I'm going to presume that private non-commercial copying is fair use. And Universal, you didn't bring any evidence that the time shift copying was going to harm your market. So, you know, the fact that you don't like it, that's too bad. Okay. Now, of course, from the standpoint of the way the world works, everybody else is like, of course, private non-commercial copying is okay. And so fortunately, the Supreme Court didn't have any protests out there. But Kastenmeier praised the Supreme Court decision in Sony in his Manges lecture many years ago. A big turning point in copyright law since the a big turning point in fair use law is Campbell versus Acuff-Rose. So Acuff-Rose owned the copyright in the music for Roy Orbison's song "Pretty Woman," and Two Live Crew came up with a rap parody version of it. And at first, Campbell went to Acuff-Rose and said, could we license this for this rap parody? And Acuff-Rose said, no way, Jose. And so they did it anyway. Of course, they sued, and part of the argument was, you came to me and asked for a license. That means that you know that you needed the license. And so that's one of the considerations that makes it unfair. And the Sixth Circuit basically found this was infringement, and the Supreme Court reversed. And this is probably the most important fair use decision that's been rendered in our lifetimes. So the court basically said, look, a parody of a song, right? So the Two Live Crew song isn't a commercial substitute for Roy Orbison's song, right? It's a critical commentary on the original, and a critical commentary on the original actually is something that contributes to culture, contributes to the purpose of copyright law. And what is transformative is that which adds something new with a different purpose or character that offers some new meanings or messages. And you have to take a significant part of the original work if you want to parody it, right? The parody won't work if you don't take anything, or you only take a little teeny snippet. And it's unlikely to harm the market for the original. And the court recognized that copyright owners don't have a sense of humor, and therefore they simply wouldn't be willing to license this, and that also ended up supporting the fair use ruling. Okay, so the court in the Campbell decision quoted and cited Judge Pierre Laval's article 13 times. Okay, so they really, that solved their problem. And so Judge Laval was the first one to identify transformativeness as something that courts should consider. And he thinks that fair use can be justified based on whether and to what extent the challenge use is transformative. And the court basically bought his definition of that term. And the court also points to transformativeness as enabling copyright to fulfill its larger public purpose and to provide some breathing room for new works to be created. So I think this is a really wise decision, and if there's one decision that of copyright law I would recommend, it would be this one. It had a really holistic conception of fair use. So it used to be, it was like a scorecard. Did factor one favor fair use? Maybe factor two didn't. What about factor three? And so it's like a little scorecard, okay? And the Supreme Court basically rejected that outright and basically said, no, you got to consider all the factors, but you also should consider them in relation to each other, right? So the more transformative it is, the less likely it's to harm the market, the more likely that something is, you had to take this much in order to make your transformative use. So the court gave this kind of balancing, real balancing approach to it. And court says no presumptions, every case has to be decided on its own merits. And that was actually, again, something that meant the court has to the courts had to take a little bit more careful approach to it. So I think Kastenmeier, who was a big balancer, would have the Campbell decision to be right up his alley. And the Campbell decision, even though Campbell obviously didn't involve a new technology, it's been very influential in a series of technological cases, most notably the Authors Guild versus Google case. Now, again, at the time that case was filed in 2005, it was not exactly likely that Google was going to win, okay? What did Google do? It went to research libraries, mostly public libraries, public university libraries, because of the 11th Amendment to the Constitution, but I'm not going to go there. But anyway, Google basically made arrangements with these libraries to basically take all of the books in their library to a facility and digitize the entire contents of the books, and then use that to make an index and also to serve up snippets. So we'll all use Google search, book search, to find information. And the Second Circuit upheld that this was a fair use because the purpose was transformative. So it's transformative in a different way, obviously, than the parody in the Campbell case, but nevertheless, it had a different purpose and a different character, right? So that meant that it was transformative. The whole works were copied, but in order to index it, you have to copy the whole thing. And it has you can only get 3 short snippets when you make a query that calls up something from Google Books. And the court found the claims of market harm to be too speculative. And again, part of what Campbell did is say, think about whether something is fair use in terms of whether it furthers the constitutional purpose of copyright. And so here you have the Second Circuit saying that copyright purposes were served because Google Book Search basically made possible access to information that you can't find any other way, right? So if you wanted to find all the books in, let's say, the University of Michigan Library that mention a particular historical entity, you can't do it. You know, there might be some book that said, oh yeah, that probably is discussed here. But now you can pinpoint to exactly the part of that you're really interested in. And it did so in a way that did not fulfill demand for the original, right? So that the snippets were too few and too fragmentary to actually be market harm in nature. Now, the most recent of the Supreme Court's cases, which has thrown a bit of a wrench in the copyright fair use community, is the Warhol Foundation versus Goldsmith case. So Goldsmith, rock musicians and the like. And in 1981, she took a series of photographs of Prince, the rock musician, and then a few years later, Vanity Fair decides that it wants to publish an article about Prince's rise to fame, right? He had been kind of somewhat known, but then he became like a superstar. And so they wanted to do a story about the rise to fame. And so they were searched around for a photograph to use as an artist reference and found in Lynn Goldsmith's agent's collection that there was a photograph of Prince that might serve well for creating an image that could then be used as an artist reference. Artist basically creates it, and then they publish the article with the commissioned work next to it. And then fast forward, Prince died in 2016, and Condé Nast decided that it wanted to do a commemorative issue, and they contacted the Warhol Foundation to ask to license what they thought was going to be what's known as the Purple Prince, which I'll show you in a minute. But they found another one named Orange Prince that they decided to put on the front cover too. And so Lynn Goldsmith sees the commemorative issue and she says, you know, I think that's based on my photograph. And so she contacted the Warhol Foundation and said, hey, that's my photograph. And you made infringing derivative works of it, and I want dollars, and you don't own any copyright stuff. All of the 16 works that were created are infringing derivatives. That's her point. And so the Warhol Foundation said, this woman's crazy, not in those words. But we're so confident that it was a fair use that they brought a declaratory judgment action, and then at the trial court level, transformative fair use under Campbell and some other Second Circuit precedents, and the court say this. That's the Purple Prince. They're kind of different. Yeah. Anyway, so the outcome, what district court said is a transformative fair use. The Second Circuit panel basically said, no, it's not transformative at all. Now, this was a fight over the 1984 creation, not about, or not just about, the 2016. Okay? The Supreme Court decides that Goldsmith had abandoned her claims about the 1984 creation being infringing, but said, hey, the 26 commercial license was a non-transformative use of the photo. So the Supreme Court basically affirmed the Second Circuit. And one of the things that it said in the opinion was that it wasn't justified because it didn't target Goldsmith's photograph for comment or criticism, and it didn't offer any other compelling justification. Okay, so that's what was going on. Now, I read that opinion, I say, you know, a superficial reading of this opinion will say that if you don't target the original for a criticism or comment, you're screwed. And so the next case that comes along is White Monkey versus Netflix. So Netflix made a documentary about Joe Exotic. Some of you may have seen the program, The Tiger King, and it included a clip from a video of a funeral, and it was shown in order to show that Mr. Exotic was a megalomaniac. Right, that was what it was about, but it didn't target the expression in the original video, and therefore it wasn't a fair use. Now, there are dozens of cases involving documentary uses of stuff, because if you want to show that the person was a megalomaniac guy, you want to actually show him in person doing it. Fortunately, the 10th Circuit granted rehearing in the case and will issue a revised ruling. But this was the danger that I was looking out for, right? This is my husband actually helped me with this slide. He said, what you need is to say, there are these boxes right now for fair use, and what you need is more boxes. So this is my paper that's in progress. And one of the things that the paper will be saying is that there's more than one kind of targeting that's been found fair use, right? So of course, targeting a work for criticism or comment is something which will favor fair use, but some cases actually target the author, right? So an older case called New Era wanted to show that L. Ron Hubbard was a cruel, bigoted, terrible human being. And the only way to show that really was to pull from his works, right? That was actually the whole point. So it wasn't targeting, did he have beautiful prose? It was basically, here's to show that he's an asshole. And then another of the cases that I focus on is targeting the subject of the work. So Klein's case, it was a case in which the website for, I think, in Madison, Wisconsin, there was a picture of the mayor, and the mayor did something that these people wanted to protest against. So they took the photograph, and then they kind of colorized it and kind of put it on T-shirts, and they got sued, and that was held to be fair use. But it was targeting the mayor, right? It wasn't targeting the photograph, and so it still was held fair use. There are other cases that target other things, but I want to say, look, targeting is not a unified thing, right? It's not just one thing. It can be a number of things. And then I see that in some of the cases that there are justifications in other factors than factor one, right? Factor one, the purpose and character of the use, but sometimes I think the courts basically say that, for example, in Google versus Oracle, programmers made huge investments in learning Java declarations, and they should be able to make of what they learned, right? Millions of programmers did that. And the reason that the Java declarations are valuable is because of their investments, not because of what Sun did. In another case, the Faulkner Literary Works case against Sony, the movie basically used that phrase about the past isn't even past. It's like, excuse me, that's like too teeny. And then factor four, the Sony versus Universal case, is speculation about it. There's nothing there. So justification isn't just a factor one issue. And then I give a series of examples of where fair use has been found when a second comer provides better access to information. And there are a bunch of cases about search engines and print disabled access to books in the HathiTrust case. There's also private interest in access to information. So one of the signal cases is actually Say versus Accolade, where decompiling a computer program in order to access information that's necessary to make a compatible program. That's the use. And here are some others, and I'm not going to go through them. It's just I'm trying to show you that I need more boxes. And so the boxes are, I think it's important to set them out just to remind the courts that there's a body of case law out there that applies fair use to pretty much everything that's in copyright. And then there are a series of cases also about economic justifications. And the post-Warhol case law, you know, it's a little bit, there's a case right now pending in the Ninth Circuit where photographer Jeff Sedlick took a photograph, which probably you have seen because it's everywhere on the internet, of Miles Davis going like this, right? And so Kat Van D is a tattoo artist. The thing on the arm of a friend of hers. And she didn't charge any money for it, by the way. And Sedlick basically says that a matter of law, because Kat Van D did not target the photograph for criticism or comment, he has to win the Warhol case. And so, hello, let me remind you. So this is kind of like what I do. So I want to end with a thought or two from the Kastenmeier Managers lecture. One of the things that I noticed when I reread that paper was that among the new technology issues that he said kind of on the horizon is, what do we do about copyright and AI? Well, it was not a big deal, actually, in 1989, because the AI winter had set in, and it's only the AI summer has only come back since 2022. But one of the things that he tried to do is say, how should courts, how should policymakers think about these kinds of new technology challenges? And one of the things that he said is that in a time of rapid technological change, Congress has two burdens in addition to maintaining an equilibrium in the law. First, it must understand the new technologies before structuring the legal system to accommodate change. I can tell you that the legislators in Congress and elsewhere do not understand generative AI one bit, okay? And second, with growing internationalization of the world's legal systems and swift flow of goods and information across borders, Congress must not only assess the domestic impact of legislation, it must also understand its consequences on foreign countries and responsibilities under treaties and international trade. So this guy was a really wise guy. He really a good kind of wise guy. So I wanted to share with you that he's one of my heroes.
Take some questions.
No, it's fine. Yeah.
Would the Art Guild case from 2015 kind of guide the AI issue now? I mean, Google took in all the books, had it, and then parsed it out like, an AI inquiry would.
Well, certainly the Authors Guild versus Google case is one of the cases that the generative AI defendants are raising as a defense, because Google wasn't using the content of the books for their expressive purposes, right? It was using them to make what Google called non-consumptive or non-expressive uses of them. And so one of the things the Second Circuit did in the Google case, again, that will be something that will be pointed to by the generative AI defendants, is that it enabled development of new tools to analyze text. So text and data mining is actually now a whole field of academic study. And Google itself developed the Ngram tool. And if you, anybody use the Ngram tool? It's really cool, okay? It's worth doing. So Ngram tool allows you to search for how frequent certain words or certain phrases have been in all of the books that are in the corpus, okay? So you can draw a map that this word wasn't used until this time, and then it went, whoops! And like, what happened, okay? So transformative, for example, is a word that if you put into the Ngram, there's not very much use of it prior to the Campbell decision. After the Campbell decision, whoop! Okay, so that's a tool that ordinary people can use, right? And Google Book Search and the HathiTrust lawsuit, which is based on the same copying, because what happened was Google made a deal with the libraries. Hey, we'll give you the books, but we want something in return. So they got in return a set of files of the books from their collections, and they have been pooled into a digital library known as the HathiTrust library. And one of the things that that does is it allows people to search for every time a particular historical character or whatever it is that you're searching for in a corpus of 15 million books. It will tell you which books actually use that term, what the call number is on the thing, and on what page you can find it. That's like a great tool, okay, for scholarly research. But the author still said, oh no, that's a terrible thing. And the HathiTrust was to enable people who have verification print disabled, they would be able to get access to the full text of the book. Because sighted people could just go to the library and get it. People who are print disabled can't. So then, because it's now all in digital form, you can use braille readers and other ways for people who are print disabled to get access to it. And the oh no, that's illegal too. It's like, excuse me. And so the Second Circuit said that was fair use also. So, you know, it's one of those things where the cases involve some facts that actually, and some holdings that the defendants in these cases are looking to. But of course, every case has to be decided on its own facts. And so we don't know what's going to happen. Yeah.
I have want to point something out, and then I had a question. So on the Home Recording Act, one of the reasons only $50 was paid out is because the tax is only on digital audio tapes, and nobody buys digital audio tapes.
Yeah, yeah. Well, the whole point is that the computer. I didn't go into this detail, but I will now. The whole detail here was that at the time that this thing was so. The Sony not only was making these VCRs, but it was also making digital audio tape machines. And they could make multiple copies of recorded music, and the recording industry was like really unhappy about that. And there was a chance that the court would say, well, it has substantial non-infringing uses too. And so under the Sony decision, it's going to be just fine. So recording industry said, hey, let's get a new solution here. And the computer industry came along and said, excuse me, you want this thing to pass? You better exempt our stuff. So what happens is the MP3 players and other kinds of technologies that use computer hard drives and not the specific type of DAT technology that was written into the statute. So they just bypassed it, right? And the recording industry bought a couple of cases actually against makers of MP3 players. And also, do you remember how we used to be able to put CDs into like a little player in our car? They sued the car makers too, and lost that one because there was all hard drives, right? And hard drives had been specifically exempted. So that was kind of the explanation for why this thing failed. Yeah.
And post my college experience, we used to engage in what we call sneaker net instead of internet, where you make copies of cassette tapes off of vinyl. In generative AI, all the cases that are going on now, I've been looking at some of them, and I happen to think the Concord Anthropic case is one of the stronger cases involving.
We'll see. I actually think that there are some others that are stronger, but
which ones and what?
I think the Getty Images versus Stability case is the most problematic for the defendant. I think with the Anthropic case, so Concord Music is one of several quite a few actually, music publishers that brought a lawsuit against Anthropic because they could prompt the Claude AI system to produce lyrics that they own copyright in. And so they had copies of the things that, here's my lyrics, and here's what Claude produced as output. And see, they're either near exact copies or substantially similar, and therefore that's infringing output. Now, you had to actually be trying to get that stuff, and you'd have to say that anytime it's output, that it's necessarily an infringing reproduction or an infringing derivative work. And if I'm just doing it for private non-commercial purposes, I want to remember the lyrics to this Stairway to Heaven or something like that. Not clear to me that that's actually an infringement, but boy, are they making a big deal out of it. And there's a preliminary injunction hearing in that case on the 25th of November. So we'll know something more about what the court in that case thinks about this stuff. But it's also the case that Anthropic has already said, look, okay, we've put in a bunch of new guardrails. Guardrails is kind of like a technological solution. So we're now basically, after we train the model with various types of, we basically put in filters saying, if you are asked to do the following things, you have to go back and say, I'm sorry, I can't help you with this, right? And so if you've seen that, use one of the generative AI companies, is because they put these filters in as guardrails, right? Or they comb through the training data and take out things that would be problematic. Again, the lawyer for Anthropic is going to say, number one, you didn't bring a preliminary injunction action like right away. Here we are, what, a year later? And that doesn't kind of like, usually courts basically say, if you wait that long, it's not a preliminary injunction case. And two is that we put guardrails in, and we've already told you we put guardrails in. So, you know, the chance of future harm, right? When a preliminary injunction is supposed to stop the forward-looking harm from happening. And if I've already shown you that I've taken care of this, you should basically shut up, right?
Are these viewed as equitable cases, or is there a role for a jury?
Well, see, the Oracle v. Google case that went up to the Supreme Court and became Google versus Oracle was tried to a jury, and a jury found fair use. And the trial judge, when Oracle made a JMAL, basically said, look, you said the facts were this, and Google said the facts were that. The jury decided that it was fair use. They must have agreed with Google's facts and not with yours. And the Supreme Court kind of is equivocal on the jury versus fact issue. So it says, oh, it's mostly a matter of, but it's of course some part of it's a matter of a fact. And yeah, in response to each of the fair use factors in the decision, Justice Breyer's opinion says, and the jury found, and the jury had this testimony before it, and the jury could have decided blah, blah, blah. Okay, so.
Did they issue standard instructions as a result?
No, of course not. But the Sedlick case was another one where I think Sedlick himself wanted to go to a jury. He lost at a jury. And now he's going to say, oh, but as a matter of law, I win. And so I'm trying to say, maybe that's not the right thing to do here. So that's kind of what that's what I do. Yeah.
One of the rights that the Copyright Act gives to the author is the right to create derivative works.
Right.
Which is defined pretty broadly.
Yep.
So I've often wondered about the tension between having transformative fair use, which is a transformation of the original, but the right of the author is includes the right to create derivative works. And so sometimes I wonder whether there's a boundary between them.
Well, it was argued in a Goldsmith case, right? That's a big argument. And actually, Oracle made some pretty same article.
Argument in the Google case. Tried to say that the Android software was a sequel
To
so the point is that you're absolutely right. The way that the
copyright scholars try
to reconcile the two is that when you're
talking about a transformative
purpose, it's talking about what your purpose was in
making some use of the pre-existing work
rather than on what
exactly you transformed in the original, right? So, so
you kind of take a bunch of characters
and plot sequences from a dramatic play and
a movie out of it. You've added
something new
with a different purpose, but that is a
transformative use
to a transformative purpose. That courts have there's
some case law that suggests that that's a
good way of doing it. My own way
of doing it is saying,
you know, it can be a transformative purpose. You may have transformed a little bit of the stuff because, like in a period,
you have to take something in order to like.
do it.
So I think that's a
kind of transformative
use, but did you take too much, right? So one of the things you can't
say, you know,
know, was it a transformative purpose? How transformative was it? Because some things are more transformative than others. And then when you get to the factor 3 amount of taking, you sort of say, did you take something, the amount that's reasonable in light of your transformative purpose? That's what the courts have been doing. So
it's like if you don't take too much, then
you may be okay. Okay. One more question.
Do you think that the overuse of the transformativeness language limits courts' analysis in trying to?
It hasn't so far. It hasn't so far, because the courts have really taken to heart the suppleness that the Campbell decision introduced to the language. Okay, so I think that actually now just because something is non-transformative doesn't mean it's not fair. So there's a series of cases about non-transformative uses that are fair. And then there are a set of cases about non-commercial uses. And the Google versus Oracle case is clearest articulation since the Sony decision that non-commercial uses are likely to be fair. So there's like little boxes for different types of uses, and none of them has to be just that. But I think a concern of at least some scholars and certainly of some people in the industry is that transformative has been eating the world and has been used too broadly. And I think one of the things that the court was trying to do in the Warhol case was to try to say, look, don't get too excited about that term. Let's be a little clearer on that. And so they took out from the Laval formulation with a new meaning or message in the reformulation of the Campbell standard. So now you're mostly looking at, was it the same purpose? Was it a different purpose? Was it commercial? Was it not commercial? And so I think there's a sense that the court was tightening up fair use to some degree, or at least responding. So in the Google versus Oracle case and in the Warhol case, there were a lot of industry briefs basically saying, cut back fair use, cut back fair use, get rid of transformative altogether. You know, they wanted to limit to targeting and to other kinds of productive uses, and the court didn't go there. Court basically reaffirmed. And part of what I do in the draft paper that I've got so far is show that if you read the Warhol decision really carefully, you can see that the court actually articulates several other types of transformative uses that it thinks were justified. So that's it, folks. I think it's time for a reception.
All right. Well, thank you so much, Professor Samuelson. Before we go to reception, however, we have one very I'm sure you at Berkeley have your own distinctive and maybe to outsiders peculiar traditions. Well, we've got them here too. And this is him. So, legend has it that several decades ago, when the old law school building was being demolished to make new for this one, there were these two gargoyles. Technically, they were grotesques, I guess, but I'm not quite sure the difference between them. But on the building, and one of them fell to the ground and was rescued by my predecessor as Dean, Dean Giorgiani. The other one was, for decades, thought to have been lost. It turns out that it was recovered by a student, Paul Bean, who just said he happened to be walking through the courtyard and found it and brought it home, and it traveled with him to Brookfield and then to Milwaukee and then somewhere in Virginia before coming back to Madison eventually. And his family apparently read a story in our alumni magazine, which is called The Gargoyle. And they realized they actually had this thing in their backyard, so one of them, the original one, now sits in the lobby to the building. The other one sits in my office. There are two lessons to this. One is that we here in Wisconsin are very tough, and we always rise from the rubble one way or another. The other is that no matter how far away you go, and no matter how many years you may be gone from this place, we will always welcome you back. So, Professor Samuelson, thank you so much for such an inspiring lecture, and we look forward to welcoming you back.
Thank you.
And beverages and food are now available in the atrium, so please enjoy. Thanks so much, everybody, for being here this evening.